Well, I wrote this book, Lawyers, Liars, and the Art of Storytelling, and I'm at least responsible for 3 of those things. I'm a lawyer. I guess I've been a liar on occasion, and I try to practice the art of storytelling. Let's think. I was a newspaper reporter for 3 years and wanted to be a writer full-time. And my father, Leonard Shapiro, who is in the book, convinced me that really what I needed to do was go to law school instead, because how could I ever make a living as a writer? So I did. I went to Berkeley, and I still worked as a newspaper reporter for 3 years while I was in law school, because Berkeley was pass-fail, so it didn't really matter. And then I got a job as a federal prosecutor, and I worked as a federal prosecutor for about 10 years. And then when my wife, who's a television writer, had twins, which I believe I was involved in, she said, you know, if you could sell a TV script, we could get double health benefits at the WGA. And that's how I became a TV writer, and that's what I've been doing for the past 14 years.
Hearing that narrative, Jonathan,
yes.
It sounds to me like your entry into screenwriting illustrates what Samuel Johnson said, no man ever wrote but for money. Is that the case?
I believe the quote, which is in my book, actually, is any man who writes for a reason other than money is a blockhead. And I believe that to be the case. Nevertheless, it's what I've been doing for the past 14 years and enjoying it for the most part.
Well, your book is about storytelling.
This one?
Yes, that one right there. And interestingly, you say that one of your biggest influences was a professor named David Daube.
Yes.
Who taught you more about storytelling than anyone else, you said, but he wasn't a lawyer himself. So what about Professor Daube? What was so important about him in your development?
Now you touch upon a serious issue, which is the man that I do sort of credit for this journey was a wonderful professor named David Daube at the University of California, Berkeley, who was the 20th century's, arguably one of the 20th century's greatest biblical scholars. And you ask, what was he doing at Berkeley Law School teaching the Bible? Well, he had a very interesting history, which I won't belabor, but he was a huge influence because he was a scholar of Aristotle. He taught rhetoric, classical rhetoric, and the concept of persuasion and advocacy very much being part and parcel to storytelling. A lot of what he wrote about was about the Bible and the ipsissima verba of Jesus' teachings and sort of the legal basis for most of Jesus' parables. I know, right? And I got a lot out of it. And so he is an inspiration for the book, and he's in the book. There's actually a mini biography of him. But sort of what I learned about Aristotle from Daube, I have always felt has put me in good stead in writing for television and in law.
Now, I actually dug up my my college volume.
By the way, so because I know this seems like radio, he's holding if I may say, a yellowed paperback copy.
Visual aid.
Yeah, if I could, just because I think
on camera. Okay. He says that rhetoric is the power of discovering the possible means of persuasion in reference to any subject. There are 3 types of proof. The first tries to establish the moral character of the persuader, so as to create confidence in his integrity. The second tries to put the hearer into a receptive state of mind. And the third tries to persuade by means of the speech itself through rational proof.
Ethos, pathos, and logos in the order of Professor Randall. Right.
And so is that it? Do you really think, did Aristotle 2,000 years ago hit on the 3 ways, the 3 important ways of persuading somebody?
Well, now, I am talking about lawyers, and it seemed to Professor Daube and to me that Aristotle did give us a wonderful framework as attorneys for building persuasive arguments, and that the most persuasive arguments use all 3. And so I can't claim to have come up with the notion of a triangle. That's something I think high school debate coaches came up with decades ago. But the idea is that if you can structure your argument as a lawyer, or as anybody else, by the way, using these 3 legs of the triangle, there's a very good chance that you'll be more successful than an opponent who does not. So yes, I think that Aristotle 2,000 years ago was a smart guy, and that's why they still have his paperback out, whereas I don't think this paperback will be out in 2,000 years. Is that your point? Because that's a hurtful thing to say.
Jonathan,
All right, sorry.
you never know. Give us some idea. How can a lawyer, as a storyteller, use each leg of the triangle?
So seems to me that as lawyers, it's all we do. From the time we pass the bar and pay our bar dues and put on a suit and tie and work in a nice office, we're trying to establish ethos. We're trying to establish the notion that whenever we speak to a client or to a judge or to a jury or to opposing counsel, we are credible and worth listening to, or someone who ought to be paid attention to. As attorneys, we are also taught or trained to think like a lawyer, which is sort of the logos notion, the idea that you're going to take the facts and fit them to the law to make the most logical, reasonable argument you can. And then the final element is you want to touch hearts, not just minds, and that's pathos. You want to attract people to your side based on some emotional connection. And in my book, I do say that we live in a time where it seems to me that pathos is the crack cocaine of argument and storytelling. We live in a time where we're so obsessed with emotion that we do a poor job, seems to me, in establishing the other two legs. We don't do as good a job as we should establishing our own credibility, both as a profession and as individual lawyers. And we certainly don't do as good a job as I think we should in doing the hard work of making logical arguments based on fact and law.
And yet you say that pathos is the hardest of all to earn with your listener.
Yes, and that's why I said it's like crack cocaine, because it's cheap and it's easy, but it's not good for you, and it's not necessarily good for those around you. I think pathos is something that can only work when it's been earned by a credible storyteller who has established through the other elements of storytelling a logical connection to the narrative that's believable and relatable and understandable. That is the basis for real pathos. It is Atticus Finch in his closing argument in To Kill a Mockingbird, which begins with his establishing his own ethos as a member of that community who is part of them. He then talks specifically about the logical elements of the case that don't support a conviction. And then he moves to pathos and talks about what he believes in and why he believes the courts are the great leveler. And then begs the jury to let Tom Robinson go. I think that's a great example of what I'm talking about.
Well, here's a quote in your book that caught my attention. It was from Arthur Train, who was a lawyer and a mystery novelist.
Yes.
Of some renown, maybe not quite as famous these days, but of some renown in his time. But a quote of his that caught my attention that you have in your book is, "The truth is greater than the sum of the facts." And then another follow-up quote, "Besides, the rules of evidence don't permit you to get the truth from a witness anyway."
Right.
So is there an element of cynicism in this? Are you suggesting that when we conduct these trials and we examine these witnesses and present this evidence as lawyers, we're not really getting at the truth, we're just doing stories?
I was actually making a more specific point, which is something that then Justice David Souter pointed out in an opinion regarding what is left in and what is left out of a trial. It's really about editing. It's not so much that you can't get at the truth in telling a law story in court. It's that we don't do, I think, as creative a job or in thinking in terms of what we leave in and what we leave out, so that jurors often have the experience. When I tried cases and I talked to jurors afterwards, so often they'd say, you know, I wish we had known more about certain aspects of the case. And I tend to agree with those reformers who say that we ought to have a broader, more liberal, more inclusive notion of evidence law that allows jurors and fact finders to consider things that, though possibly prejudicial, are often not unduly prejudicial. So that's what I was referring to. Not that the system itself is corrupt, although I think parts of it are, but that sometimes we are a little too heavy with the editing pencil when it comes to what it is that we consider relevant.
I was at a dinner once and happened to be seated next to the late Justice Otto Kaus, who was eventually on the Supreme Court in California.
California, sure.
And someone asked him, what are the rules of evidence? And his answer, and I think he wrote a treatise on evidence too, he was a scholar on that. He said, well, the rules of evidence, it's a set of rules to keep juries from knowing the kinds of things people
Juries
like
want
to
to
know
know
in
about.
making up their minds.
Yes, that's right. That's yes, and you know, the jury system has evolved in a relatively short period of time in the United States. It was the middle of the 19th century, right, when the jury as we sort of know it came into being. And in my book, I talk about new technology that's making the jury increasingly a challenge. Things like Google, things like internet searches in the jury room, et cetera. The jury system has to continue to evolve. And I think one of the ways it has to evolve is to give jurors more information, not less information. And Justice Kaus, a brilliant scholar on this issue, wasn't necessarily in favor of keeping it that way, right? He was in favor, actually, of a more progressive attitude, for example, in terms of other act evidence, of the Federal Rule 404B about evidence that you could introduce to show intent and motive and so forth. So I think that I hope that our profession is moving towards a greater sort of inclusion of evidence, not preclusion. Of course, I'm a prosecutor by training, so I would say that, wouldn't I?
Talk about this. How are they the same and how are they different? The practice of law and the writing of fiction. And by the way, it's a compound question, so you can object if you want to.
You accusing me of being a judge? I've been called a lot of bad things, but I've never been called that. Here's how they're the same. They require a tremendous amount of forethought and planning and structure and rewriting. Here's how they're different. When I was a lawyer, I couldn't make things up. And when I'm a TV writer, I can. However, you'd be surprised how limited I am as a television writer in what I can make up. So, for example, last season and this season, I write for The Blacklist, which is an NBC show starring James Spader. And last year, I wrote an episode called The Judge about I know you don't own a TV, but this is a very popular show. At any rate, NBC and Sony was very clear in terms of things we could or could not say in this kind of absurd script where a judge is not really a judge and is a vigilante and is incarcerating people who she thinks deserve to go to her own private prison. And yet even with that, we had to stay within a very sort of narrow band of what they thought was accurate. So in that sense, I guess if you were to ask me that question in a shorter way and you say, what have I learned about law and storytelling on, for example, television, I learned they're a lot more similar than different.
Well, let's move from Aristotle to Plato now.
We're moving backwards. We're going backwards in time, all right.
Because Plato was the one who warned us about believing the truth of the shadows. Remember the allegory of the cave?
Cave, yes.
And isn't there a danger for lawyers to see their job as storytellers? Isn't that a danger because they could depart from the quest for the truth? It just becomes, let's tell the best story and win the case.
What a nonsensical question you've just asked. Because Plato said, be careful of thinking there is such a thing as truth. And lawyers are always telling one side's version of the truth, right? So there can be no danger there, right? In a sense, the system is based on the notion that two adversaries will battle and the best story wins, not necessarily the truth. And I once wrote an episode of a TV show called Justice where one of the lawyers is asked after the case is over, what happened? And the lawyer played by Eamon Walker said, I don't know what happened. I don't care what happened. I'm just the lawyer. So it gets to the sort of basic premise that I love our legal system. I do think it's the greatest legal system we have, developed in the human experience. And I never mistake my work as a lawyer with that of the fact finder or the truth teller, right? We can't lie. Within the canons of legal ethics, we have to have to operate as truthfully as required under the law. But our job is to persuade. Our job is to win the case. You know, my job as a TV writer is to entertain. It isn't to be didactic, and it isn't to, like Moses, bring down the tablets.
And law is a very rich source for theater, for plays, for film, for television. It's kind of an inherent form of drama. So you think there's an easy connection between theater and
Yes.
the practice?
And I quote my old friend Peter Sagal, the host of Wait, Wait, Don't Tell Me on NPR in the book, because Peter did a wonderful series for PBS a few years ago on the Constitution of the United States. He's not a lawyer. And I asked him, why did they pick you for that? And he said, well, because I'm a storyteller. And the Constitution is about conflict. All great drama is about conflict. It's about somebody wants something, and somebody else wants something different. And there is no better way to present that than in a legal setting, in a courtroom setting. I mean, it's why, going all the way back to Ephraim Tutt, the character created by Tran, and even before, through a great Ventura County District Attorney, Earl Gardner Stanley, Perry Mason, through Viola Davis and How to Get Away with Murder on ABC. Law lends itself to storytelling and to drama because of its inherent structural elements.
Now, you've also been a noted reviewer, Jonathan. You've written a lot of book reviews. Question, do you think a critic is a storyteller as well?
Oh, that's a really good question.
At least it's not nonsense like my last one.
That was harsh. I regret that. That was
We'll
unfairly critical.
We'll discuss that later.
Okay,
I'm going
to get a beating.
Wait, actually, I'm going to bring that point up now. Remember, Plato's point was there was some absolute truth,
Yes.
and the shadows on the cave
Correct.
were just
subjective
mere
and
images
yes.
of the absolute truth.
Yes. I guess because I am an Aristotelian, I don't believe in the notion of a Platonic truth. And I don't know that as lawyers or as Americans or as enlightened people, any of us should think in terms of a objective truth. Because that it seems to me to be the road to fundamentalism and a kind of intellectual hobgoblin of a little mind state. So as a lawyer, what I love about being a lawyer is the subjectivity of it. I actually embrace that, and I think it's a wonderful aspect of it. You asked me another question. I've completely lost track.
But I love that answer you just gave us. That was great.
Okay.
But let's talk about when you write as a critic. Is a critic
yes, excellent.
Too?
Yes.
Is a critic a storyteller too?
That is a wonderful question, and I don't have a quick answer for it because it's something I wrestle with all the time, both as a critic and as one who is criticized. One of the horrible aspects of life is it's too long, and so what goes around actually does come around. So for years I was a book critic, and then I became a TV writer, and my TV shows would be reviewed. I mean, all the time, right? And some of the reviews were wonderful, and some of the reviews were just libelous. I mean, as if I had committed a crime of some kind. And I realized that the critics are storytellers, and that as a critic, I am a storyteller. And if I'm a fair critic, I'm trying to tell the story that the author actually wrote, rather than the story I wish the author had written, or the story I might have written, or another story that has nothing to do with the story he wrote. And I think being reviewed has made me a fairer critic and a fairer storyteller, because it's led me to be more disciplined in the story I tell about the material I'm reviewing.
Okay, well said.
Thank you.
Last question. Who do you want to see read your book and why?
Well, I got a wonderful email from a young first-year law student who read an advance copy and was very excited about the idea that he is embarking on a profession where he'll get to be a storyteller. And I thought, that's exactly who I would like to read the book. I would like people who are thinking about being lawyers, or people who are in law school, or people who are lawyers, to look at the book and to read it and to see it as I intended it to be, as a celebration of what I think is marvelous about our profession. I think there is no greater human interaction other than sex than storytelling. And I think as lawyers, we're paid to engage in storytelling. It's what we're supposed to do as advocates. And the book is intended for people who haven't thought of it like that, or perhaps have and have forgotten it, or perhaps never thought of it that way. So those would be my ideal. And also people between the ages of 18 to 34 who have a lot of disposable income, because in TV, that's the gold standard of markets. That's who I want to read, particularly in urban areas.